Ready?
Yep.
Members of the jury, you have had pointed out to you in prior cases the fact that your judgment is to determine the questions of fact that arise in these cases. What are the questions of fact that are to be determined by you here? This plaintiff claims the right to recover damages from the defendant because of injuries alleged to have been received by him on the 31st of August through the negligence of the employees of the defendant. The plaintiff claims that he was about to board a standing trolley car in the borough of Brooklyn on that day when the car was started without giving him an opportunity to leave the running board and get in the space between the seats, and that the injuries he received were due to the negligence of those operating the trolley car. The defendant claims, on the other hand, that the plaintiff attempted to board the car while it was in motion and attempted to board it at a point in close proximity to the standing truck, that he was injured not through the negligence of the defendant, but through his own negligence. So you can see that the issue of fact comes from those conflicting stories told by the witnesses on both sides. The first duty that you are to perform is to determine how this accident happened. Negligence is, as it has been defined to you, is the failure to use that degree of care and caution that a reasonably prudent person would use under a given set of circumstances. The circumstances here, to a certain extent, are admitted. It is admitted that the defendant operated a street railway, and it is conceded and not disputed that the plaintiff attempted to board one of its cars as a proposed passenger. The circumstances of his boarding the car, where he was, whether it was in the ordinary place for passengers to enter, whether the car was standing still or moving, the distance from the truck standing alongside of it are in dispute. The plaintiff must satisfy you that the accident happened substantially as he says it did, that the conductor and motorman of the railway company, or either of those, were negligent. That is, that they did not exercise reasonable care and that they did not give him a reasonable opportunity to board the car and get to a place of safety before they caused it to be started. If the plaintiff does satisfy you that the accident happened in the manner that he says it did, or substantially as he says it did, he cannot recover here. He cannot recover here upon a different theory. I charge you as a matter of law that if the plaintiff attempted to board the car after the car had started, and while it was in motion and in close proximity to the truck at the point where he was getting on his own admission of the facts, he cannot recover anything here because it would be proper for you to find contributory negligence of the plaintiff if he attempted to board a moving car while a truck so close to the point where he was boarding it was there. So you can see the reason for the role that the plaintiff must prove the accident happened substantially as he says it did. You will see there are two conflicting stories here. It is important to determine just first how this particular accident did happen. Was the car standing still? Was it in motion? It was, if you find that the accident happened substantially as the plaintiff says it did, that is to say that the car was standing still when he attempted to board it. Nevertheless, you may find him negligent here, or you may find negligence, depending upon whether you find that there was reasonable care exercised by those operating the car. The plaintiff was entitled to a reasonable opportunity to get into the car, both onto the running board and into it. He was entitled to do so without those operating the car failing to use reasonable care to guard his safety. He must show you, however, that they did fail in their duty to exercise towards him reasonable care. In other words, if even though the car was standing still, you need not necessarily find negligence. You might find, because of the place where he entered the car, because of the circumstances under which he entered the car, there was no lack of care on the part of those operating it in starting it under the circumstances. On the other hand, you may find